Hello and welcome to the 2023-2024 Annual Civil Rights Training. This training is sponsored by the Arkansas Department of Education, Division of Elementary and Secondary Education, Office of Early Childhood, Food Distribution Unit. In today's training, we will discuss the Civil Rights Program, legal authorities, and all areas of compliance. Assurances, public notification requirements, complaints of discrimination, civil rights training, race and ethnicity data collection, limited English proficiency or LEPs, disability compliance, resolution of noncompliance, conflict resolution, and customer service. So why must everyone complete a civil rights training? Well, this training is required so that individuals involved in all levels of administration of USDA programs that receive federal financial assistance understand federal laws, regulations, instructions, policies, and other guidances. Here are the civil rights laws. In 1964, Title VI of the Civil Rights Act protected race, color, national origin. In 1972, Title IX of the Education Amendments protected sex, but that was amended in May of 2022 to include gender identity and sexual orientation. In 1973, Section 504 of the Rehabilitation Act protected disability, and in 1975, the Discrimination Act protected age. Now here is the list of Civil Rights Program authorities. Civil Rights Restoration Act of 1987 clarifies the scope of the Civil Rights Act of 1964. 7 CFR, which CFR stands for Code of Federal Regulations, and 7 is the Agriculture Code of Federal Regulations. Part 16 states that equal opportunity for religious organizations. Executive Order 13166 in August 11, 2000 said improving access to services for persons with limited English proficiency. And USDA Limited English Proficiency Policy Guidance 79 Federal Regulation number 229, page 7077, Friday, November 28, 2014. Other civil rights program authorities include the 7 CFR Parts 15, 15A, and 15B. These are the non-discrimination with education projects and handicaps. We have 7 CFR Part 226, which is part of the Child and Adult Care Food Program. We have the 28 CFR Part 42, which is non-discrimination in federally assisted programs, which is the judicial administration. And of course, USDA Departmental Regulation 4330-2 prohibits discrimination in programs and activities receiving federal financial assistance from USDA. And the Food and Nutrition Service Instruction 113-1 in Appendix B also talks about the Child and Adult Care Food Program. So what is discrimination? Well, discrimination is the act of distinguishing one person or group of persons from another, either intentionally, by neglect, or by the effect of actions or lack of actions based on their protected classes. But what is a protected class? A protected class is any person or group of people who have characteristics for which discrimination is prohibited based on a law, regulation, or executive order. So what are the 6 protected classes? Well, 1, you have race, 2 is color, 3 is national origin, 4 is sex, and this includes gender identity and sexual orientation. 5th is age, and 6th is disability. Now let's talk about the areas of compliance when it comes to civil rights. The first is assurances. Every year in your agreements or contracts, you must have a written assurance that your agency will operate in compliance with all civil rights laws. The assurance statement must be incorporated in all agreements between federal and state agencies, state and nutrition sponsors, and their subrecipient agencies. The second area of compliance is public notification requirements. All food and nutrition service programs must have a public notification system in place. The elements of public notification system include program availability, complaint information, and non-discrimination statement. With program availability is to inform applicants, participants, and potential eligible persons of their program rights and responsibilities and the steps necessary for participation. With the complaint information, it's to advise applicants and participants at the service delivery point of their right to file a complaint, how to file a complaint, and the complaint procedures. Non-discrimination statement, all information materials and sources, including the websites used by FNS, state agencies, local agencies, or other subrecipients to inform the public about FNS programs must contain a non-discrimination statement. It is not required on every page of a website. At a minimum, the non-discrimination statement or a link to it must be on the home page. Methods of public notification include make program information available to the public upon request, prominently display the Injustice for All posters where every one of your participants can see them, not just in the office. Inform potentially eligible persons, applicants, participants, and grassroots organizations of programs or changes in your programs. Convey the message of equal opportunity in all photos and other graphics that are used to provide program or program-related information. And provide appropriate information in alternative formats for persons with disabilities and in the appropriate language or languages of LEP persons that participate at your facility. There is a Code of Federal Regulations for Religious Organizations. 7 CFR Part 16 notes ensures a level playing field for the participation of faith-based organizations and other community organizations in USDA programs. This is the non-discrimination statement. This is what needs to be posted on your website, or at least a link to this statement must be posted on your website. And all of your flyers, brochures needs to have the statement that is at the very bottom that states this institution is an equal opportunity provider. And if you notice in paragraph 3, to file a program discrimination complaint, a complainant should complete a form AD-3027 USDA program discrimination complaint form, which can be obtained online at this website or at any USDA office, or they can call 866-632-9992, or by writing a letter addressed to USDA. The letter must contain the complainant's name, address, telephone number, and a written description of the alleged discriminatory action in sufficient detail to inform the Assistant Secretary of Civil Rights about the nature and date of the alleged civil rights violation. And if they want to submit the letter, they can mail it, they can fax it, or they can email it. This is what the And Justice for All poster looks like. All agencies participating in FNS nutrition assistance programs, state or local agencies, and their subrecipients must display the USDA's non-discrimination poster in a prominent area where participants and potential participants have access. The third area of compliance is dealing with complaints of discrimination. Complaints shall be accepted and forwarded to USDA. Complaints must be filed within 180 days from the alleged act of discrimination. Complaints may be written, verbal, or anonymous. State agencies and subrecipient agencies may develop their own complaint forms, but the use of such forms cannot be a prerequisite for acceptance. A separate civil rights complaint log shall be maintained by the state and subrecipient agencies. And confidentiality is extremely important and must be maintained at all times. This link describes the civil rights complaint process in detail and includes the USDA complaint form AD-3027. This one is in English, and once they have the Spanish and other languages available, we will place that on our website. Here is the link for the English version of the Civil Rights Complaint Form. In this link, it also describes the process and how to fill the form out correctly. This is what the Civil Rights Complaint Form looks like. The complaints should include name, address, and telephone number of the complainant, the location and name of the organization or the office, the nature of the incident or action, the names, titles, and business addresses of the persons who may have knowledge of the discriminatory action, the date or dates during which the alleged discriminatory action occurred, and the basis of the alleged discrimination. The fourth area of compliance is the annual civil rights training for staff. All staff, including the volunteers, should receive training on all aspects of civil rights compliance, including the collection and use of data, effective public notification systems, complaint procedures, resolution of noncompliance, requirement for reasonable accommodations of persons with disabilities, conflict resolution, and customer service. The fifth area of compliance is race and ethnicity data collection. As a means of monitoring civil rights compliance, state and recipient agencies shall establish a system for the collection of racial ethnic data of each person applying for and receiving benefits. But the applicant must be assured that the information is required for and used for statistical purposes only and has no effect on eligibility criteria. The data should be collected at the point of the application and retained at the service delivery area. To obtain the race and ethnicity data, there are two questions that they must answer. One is ethnicity. They are to check Hispanic or Latino, non-Hispanic or Latino. The second question is about race. They can pick one or more of the following: American Indian or Alaska Native, Asian, Black or African American, Native Hawaiian or other Pacific Islander, or white. The sixth area of compliance is limited English proficiency, or LEP. State agencies, local agencies, and other subrecipients that fail to provide services to limited English proficiency, LEP, potentially eligible persons, applicants, and participants, or deny them access to federally assisted programs and activities, may be discriminating on the basis of national origin in violation of Title VI and its implementing regulations. Title VI and its regulations require state agencies, local agencies, and other subrecipients to take reasonable steps to assure meaningful access to the information and services they provide. You can also find this in FNS Instruction 113-1, Section 7. So who are the limited proficiency people, or LEPs, and what does it mean by meaningful access? Well, who are individuals who do not speak English as their primary language and who have a limited ability to read, speak, write, or understand English. What it's meant by meaningful access, this is accomplished by providing reasonable, timely, appropriate, competent, qualified, accurate, and effective language services to individuals with LEP when accessing recipient programs and activities. There are 4 factors to consider in addressing LEP. The first one is the number or proportion of LEP persons served or encountered in the eligible population. You can look at your census to determine. The second one, frequency with which LEP individuals come in contact with the program. The third one is nature or importance of the program, activity, or service provided by the program. And your fourth one is resources available to the recipient and costs. Here are some resources you can use to help determine the factors in addressing LEP. The 7th area of compliance is the disability compliance. Section 504 of the Rehabilitation Act of 1973 and USDA Implementing Regulations 7 CFR Part 15B prohibits the discrimination based on disability in programs or activities receiving federal financial assistance. Americans with Disabilities Act 28 CFR Part 35, Title II, Subtitle A, prohibits discrimination based on disability in all services, programs, and activities provided to the public by state and local governments. These civil rights laws protect persons with disabilities if they are potential applicants or participants in any FNS-funded programs. What is disability discrimination? That's when you discriminate against a person who has a physical or mental impairment which substantially limits one or more major life activities, has a record of such an impairment, or is regarded as having such an impairment. These major life activities include functions such as caring for oneself, performing manual tasks, walking, seeing, hearing, speaking, breathing, learning, and working. It also includes functions of the immune system, normal cell growth, digestive, bowel, bladder, neurological, brain, respiratory, circulatory, cardiovascular, endocrine, and reproductive functions. These were all amended for the American Disabilities Act, Amendments Act of 2008. So what must you do as an agency? Well, the ADA requires public entities to make reasonable modifications in their usual ways of doing things when necessary to accommodate people who have disabilities. For example, you could provide braille or large print, audio tape, or other auxiliary aids or services. The 8th area of compliance is the compliance review. This is where we examine the activities of state agencies, recipient agencies, and sub-agencies to determine civil rights compliance. FNS civil rights and program staff review state agencies. The FNS staff and the state agencies review the recipient agencies. And if there are significant findings, we must provide in writing to the review entity and to FNS. There are 3 types of compliance reviews. The first one is the pre-award. This is done prior to approval of federal financial assistance. The second one is the routine, or the post-award. This is where this commodity distribution unit comes in and makes sure that you are following all compliances. The assurances, public notification, racial and ethnic data collection and reporting, civil rights complaints, compliance reviews, resolution of noncompliance, civil rights training, disability compliance, and LEPs. The third one is special compliance reviews. It may be scheduled or unscheduled. It may be a follow-up on previous findings of noncompliance. It may be to investigate reports of noncompliance by other agencies, media, or grassroots organizations. It may be specific to an incident or a policy. It also may have a history of statistical underrepresentation of particular groups. And it can also be done to see if there's a pattern of complaints of discrimination. So we've done the review and we see that you are in non-compliance. So here's the resolution of non-compliance. A factual finding that any civil rights requirement as provided by law, regulation, policy, instruction, or guidelines is not being adhered to by the state agency, local agency, or other subrecipient. So steps must be taken immediately to obtain voluntary compliance. A finding's effective date is the date of notice to the reviewed entity. If there are non-compliance findings, an agency may agree to a voluntary resolution agreement, or VRA. This is an agreement that recipient or recipients are willingly consenting to undertake remedial actions to address identified areas of non-compliance or in violation with applicable civil rights laws and/or regulations. It may be between multiple parties, such as the officials in authority to regulate civil rights laws, the recipient or subrecipient agencies, and the program participant. It may be used to close out a civil rights compliance review at the discretion of the FNS Civil Rights Department in lieu of issuing a written compliance review report with findings. The ninth area of compliance is conflict resolution. We may not all agree, but we do have to come up with some kind of resolution when there is conflict. USDA has provided a conflict resolution worksheet that can be found at this link, and this is what the resolution worksheet looks like. It is something that both parties would fill out, and then there would be a mediator that would help with the process. The 10th and final area of compliance is customer service. The mission of the USDA Food and Nutrition Service is to increase food security and reduce hunger in partnership with cooperating organizations by providing children and low-income people access to food, a healthy diet, and nutrition education in a manner that supports American agriculture and inspires public confidence. We need to make sure that we are providing the best customer service to all of our participants so that we can follow the mission of the USDA. Thank you for taking time to view this training. If you have any questions, please call our unit at 501-371-1400 or email us at oec.commodities@ade.arkansas.gov. You can always email your program specialist and you will find their email address over to the right. Have a wonderful day. In order to receive a certificate of completion, you must complete the quiz. The quiz link can be found in the description of this video. You must pass with a 70% or higher. Once that is done, we will email you a certificate of completion within 5 to 7 days.